That's a good question, and that happens quite often where the victim says, I no longer want to charge this individual with the domestic violence charge, or I'm changing my story. It didn't happen that way. Again, this is very similar to even just a normal battery charge in that the state is the one who makes the ultimate decision. If they believe that they can still pursue the charges against you, even without the cooperation of a victim, it is their duty to protect society and determine whether or not they can still prove those charges. And depending on the situation, they may end up dropping the charges, or they may end up taking their chances, and if you wanted a jury trial, to see if the victim shows up. So ultimately, the answer is it's not up to the victim, nor is it up to the individual that's being charged. The state makes the decision. So depending on the particular case, if the victim doesn't show up at trial and the state feels that they cannot prove their case without the victim, then your case could be dismissed. However, if the state believes that they can still prove your case without the victim being there, then they could continue to go to trial and say that they believe that they are able to prove the case, and you and your attorney would then have to be prepared to still try the case even if the victim doesn't show up.
What is it?